Good morning, ladies and gentlemen, and thank you for being with us. First and foremost, we hope that you and your families are holding up okay during these challenging times. I'm Frank Pina, a principal with Mercadien PC Certified Public Accountants, and joining me today to lead our discussion are Sherry Ritter, Kyle Neild, and Lee Boss, all of whom are CPAs and principals of Mercadien as well. Sherry and Kyle lead Mercadien's nonprofit and human services group with a focus on accounting and consulting, audit and attestation, as well as risk management services. Lee Boss, in addition to his involvement with firm leadership and administration, he's responsible for the firm's overall audit and attestation practice, but with a focus on business and financial consulting for privately owned companies. Today's webinar discusses the Paycheck Protection Program, or PPP, as we'll refer to it throughout the presentation. It's also going to cover a variety of the aspects of the program, including nuances around borrower eligibility, maximum loan amount calculations, and some of the loan forgiveness criteria, which is still developing. It'll also cover how the PPP might impact your organization and what you can expect to encounter as you navigate through this process. Along the way, we're going to talk a little bit about some of the tips and techniques and even some of the pitfalls that we've encountered as we walked our clients through this application process and what we believe we can expect on a go-forward basis as the guidance rolls out. Additionally, Mercadien advisors will talk about how they can help your organization better understand the programs, specifically the PPP, but other relief options that might be available to you, and how you can go about getting more information to that extent. And at the end, we'll leave about 15 minutes for questions. So I want to thank everyone for submitting their questions in advance. And also feel free to use our live chat feature, which we'll continue to monitor and hope to cover as many questions as we can in the time frame allotted. In terms of some background, the CARES Act, which is the largest economic bill in US history, added a new product. And that product is the PPP, or the Paycheck Protection Program. And it was added to the Small Business Administration's existing 7A loan program, which many of you are probably familiar with. Congress intended the PPP to really serve two fundamental functions. The first of which is to help small businesses cover their near-term operating expenses during what many believe to be the worst of the COVID-19 crisis. And secondly, it's really to provide a strong incentive for employers to keep their employees employed. The program provides potentially forgivable loans up to $10 million at an interest rate of 1% over a 2-year term to be used for payroll and other eligible expenses so that small business borrowers can utilize these funds to weather the storm. These small business borrowers have to have been in business on February 15th of 2020. Each borrower is provided under the program with payment deferment for 6 months up to a year, and there are no prepayment penalties for any unforgiven balance. The program also provides for fee waivers and what is being called a streamlined application process that both of which will be discussed in greater detail momentarily. Given the impact that coronavirus is having on small businesses, it's become critically important that small businesses understand what relief options are available and get the access to the capital they need to weather this crisis until normal business operations can resume. However, keep in mind that this is a rapidly changing environment, and while we believe our information is up to date through this point in time, things could change as regulatory guidance rolls out and we hear more from the Treasury or the SBA. So I would encourage you to check back with us, visit our website frequently for additional information. And with that, I'll turn it over to Sherry. Thank you.
Thank you, Frank. I just want to make sure that you can hear me okay.
We can. Thank you, Sherry.
Okay, great. So we're going to talk about business eligibility and the base that you can borrow. So who's eligible for the PPP loan program? It's available to businesses that have 500 or fewer employees based on the average of their employment base over the period of time that goes into the payroll cost base. So what does that mean? Essentially, if you have 500 or fewer employees as of the date that you are applying for the loan, and in your base period, which we're going to talk about in a few minutes, where you calculate how much loan you're available for, you have an employee head count that you're going to be using. So if you're on the cusp of a 500 employee head count, you're probably going to want to check the numbers carefully. But the general rule is that businesses with fewer than 500 employees can apply. Eligible nonprofit organizations with fewer than 500 employees can also apply. And this includes your 501c3 organizations. We've had a lot of questions from clients asking if they're a 501c4 or a 501c6, which is a trade or professional association. Can they apply for this loan? And the answer is no, there are other options for them. Eligible veterans organizations are included, and tribal businesses that are defined by the SBA are also included. What's interesting is individuals who are self-employed, who normally don't count as an employee, in their own business, but who regularly carry on a trader business, can also apply. So, for example, my daughter, who has a cleaning business, she's self-employed. Last year, she had a couple of employees, but by the end of last year, she was doing handling her business on her own without employees. By this Friday, I plan on helping her make her own application for the program. Individuals who operate as independent contractors or sole proprietors. This is interesting because in my mind, an independent contractor providing personal services or professional services is a self-employed individual and may also file a Schedule C, will likely file a Schedule C on their personal income tax return, and we normally refer to those individuals as sole proprietors. So the language, to Frank's point a minute or so ago, the language in the Act tends to be a little contradictory or unclear at times, and so there's a lot of confusion and ever-evolving interpretations of what's of how to apply what we're reading in the Act. So I can't see you guys advancing the slides because of my internet issue. So how much can you borrow? So I'll just make sure that you're on the next slide, Ashley. Loans can be up to 2.5%, or excuse me, 2.5 times the borrower's average monthly payroll costs in 2019, not to exceed $10 million. This is what the Act says. There's an exception for non-seasonal employers where they can use 2.5 times the average total monthly payroll costs during the year prior to the loan date, and 2.5 times the average total monthly payroll costs for January and February 2020 if you weren't operational. And I actually have a couple of clients who weren't operational, so they're using that January and February time period to determine their base. For seasonal employees, you can use the 12-week period beginning February 15, 2019 through June 30, and that's basically a comparable period to where we're at right now, and the same time frame for which this loan is going to be covered. It's going to cover payments out of your loan proceeds through June 30, 2020. So what are payroll costs? Payroll costs are all of the payments that are included in compensation with respect to your employees. So that includes your salaries, your commissions, any type of paid time. So it includes if you're a restaurant or a business that receives tips, it could be, like a barbershop or something like that. It could include your cash tips and equivalent compensation. It also includes all of your paid time off, so vacation and sick, any type of leave, sick leave, medical leave, separation payments. So any type of compensation that you that you pay your employees is part of the payroll base. You then also include payments for the employer's share of group healthcare benefits. So what does that mean? We've had to, as a firm, we've gone back and forth on, does that include long-term disability? Does that include workers' compensation? Does it include vision and dental? Basically, if it's healthcare related, we've come to the conclusion that it includes your health insurance premiums, and if you happen to have a vision or dental plan included with your healthcare coverage for your employees, then to the extent that you as an employer are covering those premiums and or costs for your employees, that can be added to your base. It also includes payment of retirement benefits. So this is not the amount that an employee would defer from their salary for their 401k. This is the employer match that we're talking about. So as you can see, it's really all about determining your costs as an employer of carrying your employees. It also allows you to add state or local tax that you pay on your compensation to your employees. So if you're a New Jersey employer, what we're talking about here is your unemployment insurance, your part of the premium as an employer, disability, family leave, and those types of costs. You're not allowed to include your share of FICA or Medicare costs or FUTA costs. They're specifically prohibited. So what if you're a sole proprietor or a self-employed individual? And we actually have a number of clients who are partners in partnerships. Maybe they receive a guaranteed payment, and then they also are eligible to participate in the profits of the partnership. And the same for a self-employed person who files a Schedule C. How are we going to determine, what the payroll base is for those individuals? That's the information that you're going to submit in order to make your application is going to be a copy of your Schedule C from the prior year, 2019. If you don't have it done yet, what we're doing is we're recommending our clients do a pro forma Schedule C because not everybody's got their returns done at this point. For a partnership, it would be the K1 that shows the amount of income that the partner receives from the partnership. We're also going to be asking our clients to submit a listing of all of the draw payments that they took out of either the partnership or their sole proprietorship. So if you think about a sole proprietor who grosses $250,000 during the year from servicing their clients and customers, they have $150,000 of expenses against that. They're left with $100,000 of net income from self-employment. It's that net income from self-employment that is going to go into the payroll cost base. Now, they're capping the amount of payroll that can be included in the base to $100,000. So to the extent that you have more than $100,000 in compensation that you pay to any particular employee, that has got to be pulled out of the base, but we'll talk about that in a minute. So when can you apply? Well, last Friday, April 3rd, was the opening day, shall we say, for making application for most businesses. And it didn't go off so well. So I'm sure many of you on the call have heard about I'm going to call it chaos, because that's really what it felt like, that took place when individuals were trying to go online through their online banking. They either got a message that the portal wasn't ready, or the sites were crashing, the applications really weren't ready to be utilized at that time. So over this past weekend, a lot of the banks finally got themselves up and running. Their portals are open. Their applications have been tweaked so that you don't get kicked out of the system while you're making the application. But so April 3rd was the key date. April 10th, which is this coming Friday, is when independent contractors and self-employed individuals can apply and receive loans. So what I'm differentiating here, what I take this to read, April 3rd is for those sole proprietorships that actually have employees. April 10th really relates to those people that may file and consider themselves a sole proprietor, but they're self-employed and they don't have employees. And if they're an independent contractor where you receive 1099s at the end of the year, that's the April 10th date differentiation. You have until June 30, 2020 to submit your application, but this is a first come, first serve process. And we're encouraging everybody to make their applications as quickly as possible. The banks have their lending limits. And so some of the banks, I believe, Frank, maybe you can talk to this point, but have already closed their portals because they've maxed out their loan capacity. Can you add anything to that, Frank?
So I think that's a lender by lender specific situation, but you are correct. We did hear that certain banks have closed their window, and at some point, other banks are working with existing borrowers as compared to taking on new customers. So since it's a lender delegated authority here, we encourage you to talk directly with your lender to find out what their particular situation is and how it might affect your organization and your application.
Okay, great. So, and to that point, each bank that is an authorized SBA lender has its own application checklist. So the application that you'll use to request the loan is an SBA form. However, each bank has the ability to process their loans and ask for their documents in their own format. We've actually seen that, I think, as late as yesterday or today, where there's guidance coming out from the SBA, from the AICPA, from the different banking institutions or associations, I should say, where they're trying to get everybody to standardize the information that is being requested in addition to submitting your loan application, because that in and of itself is causing confusion. So let's talk for a moment about what's not included in that payroll cost base. As I mentioned earlier, you're only allowed to include up to $100,000 of compensation. So yesterday we were working with an S corporation, and S corporations have unique rules where the shareholders have to include in their compensation their health insurance premiums. So if that shareholder has compensation over $100,000, which includes the health insurance premium, then you would at first blush think that they're not going to be able to get the benefit of the health insurance premium being part of the base. Well, the position we're taking as we go through these calculations is that health insurance comes out separately. So if somebody's making $150,000, they have a $10,000 health insurance premium added to that, so their taxable wages are $160,000. We're pulling the 10 out, putting it on the health insurance cost line, and then leaving $150,000 of compensation, and then capping that 150 at the $100,000.
Jerry, this is Lee.
Yep.
The SBA actually gave some FAQ guidance on that yesterday, or as of April 6th, which clarified and confirmed that that is the position as well. That you wouldn't limit the healthcare costs for employees where you otherwise would cap their salary.
Yeah, that would be contradictory to the spirit, I think, of what they're trying to allow. So, but absent seeing anything in black and white, this is what we've been dealing with, having to either take positions because people want to get their applications in quickly, as you would expect, and we absent clear guidance, we're just having to look at and try to figure out what the spirit or intent of the regulations and the act are. The other items that are excluded from payroll costs are compensation. If you have employees who reside outside of the U.S., you have to pull that compensation out of your base. And also qualified the sick leave wages. So the acts have come out. There are 3 acts so far. There was the original, overall response to the pandemic and how it impacted the economy. The second act that Congress passed was the Families First Corona Response Act, FFCRA. You may have seen it, and that really provided for mandatory. It's mandatory that employers provide 80 hours of sick time to certain employees if they were directly, and this is key, directly impacted by the virus, meaning they thought they had symptoms, they were told to quarantine because they were exposed, they actually had the coronavirus, or they were taking care of a family member that was like a child that's home from school. So those were specific, that act was geared specifically towards people directly impacted by the virus. And so employers have to pay 80 hours of sick time to their employees if the employee is eligible based on their impact, and they have to cover them up to 10 weeks of paid family leave. So the purpose of today's webinar is not really to get into that, but everybody should understand the implications of that act on their business. There are exclusions for businesses under 50 employees. However, for purposes of what's not covered in your payroll base, if somebody was paying this FFCRA leave or sick time to their employees, let's say between February 15th and March 31st, you would pull that compensation out of the base for purposes of applying for the loan. And then what will happen is you'll make application of the loan. So let's say that your base is, I'm going to keep it simple, $100,000. And so you've come up with all of your payroll costs, including your wages, your healthcare costs, and your pension costs. Your total wages over the year were $1.2 million. You divide that by 12, you get $100,000 monthly average payroll cost. Multiply that by 2.5, and you're eligible for a $250,000 loan. So if you look at the application, you can go online and see it, or it's available on our website. That's the loan amount that you're eligible for. Then, and you also have to attest that when you make application, that you're going to use it for payroll, rent, utilities, or interest expense on mortgages or loans that you were obligated to prior to February 15th. I think I think that we're in good shape. Lee, I think I'm going to kick it over to you.
Sure. Thank you, Sherry, and welcome everybody. I just wanted to highlight a few things that Sherry spoke of that we've been keeping close watch on the CARES Act and how this PPP loan has evolved over time. It's been a bit elusive in many respects trying to get our hands around it, and a lot of that has just been because of the quick turnaround and time frame. When we look at it, the CARES Act was actually signed into law by President Trump on Friday, March 27th, and the intent was to try to get the PPP loan applications start to have those accepted a week later on April 3rd. However, the SBA, Department of Treasury, didn't issue final or interim regulations, we refer to them as, until I think it was actually the Thursday before, which was April 2nd. So there was a lot of reading the CARES Act, understanding what the eligibility and different requirements of the PPP program would be. However, the guidance didn't come out until, about a week later, a day before they intended to start accepting applications. So the banks obviously were scrambling, as all of us were, trying to understand it, what was required. And frankly, a lot of additional guidance came out subsequent to April 3rd. Recently, there was an FAQ, a frequently asked questions document, that was issued, I believe, on Monday. It's actually April 6th that came out that clarified some of the aspects of the interim rules, but there's still some areas that are still subject to interpretation or additional guidance that will come out from the SBA, Department of Treasury. So it's been a bit of a challenge. They also gave out some guidance on some affiliation rules dealing with when you have a shareholder or an owner or somebody that controls the business, generally a 50% greater owner, and when you may have to aggregate different employers for determining whether you actually are a small business. So there's more guidance out there, especially on the SBA website, that we would encourage all of the participants to review as it may apply to your business. But the bigger issue that we've been having right now is bank clients and applicants finding an approved SBA lender in order to submit an application. That's been a real challenge, frankly, that we've seen over the past few days here. The guidance initially that we reached out to our banking contacts, and what we were receiving feedback on was that those banks are only going to be accepting applications on behalf of their customers. That's kind of the first priority. That was the stance that many of the banks took. And many of the banks continue to take that stance. As Sherry indicated, some of the banks have actually closed up shop at this point from accepting PPP applications. We understand, for example, Wells Fargo stopped accepting applications, I believe it was yesterday, under the PPP program. I have a client that works with Citigroup, and Citigroup's website, as of yesterday at least, was still kind of under construction. They didn't start accepting applications yet. So a bit of a challenge, causing a lot of anxiety for all the small business owners, especially as they're being impacted significantly by COVID-19 and really looking to get the funding that's entitled to them under the CARES Act. So the first thing we're recommending our clients, the applicants, do is reach out to your existing bank. I think that makes the most sense and probably is going to be the easiest path forward for this, is to talk to your existing bank if you haven't already done so, see if they are accepting the PPP loan applications. The SBA actually creates through existing SBA 7A lenders, it's kind of the fast track. They actually, in the interim rules, said that they could start accepting, existing 7A lenders could start accepting applications pretty much immediately. Other banks that were not, or lending institutions that were not already SBA 7A lenders can also accept PPP loan applications. However, they have to, one, meet the requirements that are listed in the interim regulations, but they also have to file a form 3506 with the SBA in order to accept those PPP loan applications. So again, encourage all of you to reach out to your existing bank. Understand that there has been a lot of frustration out there by the banks, and many of them are not yet accepting fully applications. There are other non-banking SBA lenders out there. We encourage all the attendees, if you haven't reached out to your bank already, you can also find lenders at the website listed, sba.gov. There's actually a search feature there where you can search for lenders. I'm currently working to get kind of a compiled list of non-bank SBA lenders for my clients as they're facing some challenges with a few of those lending institutions that we mentioned. So just the next thing we wanted to talk about is kind of what lenders are looking for. And as Sherry indicated, it is a little bit of a mixed bag right now as far as what lenders are requiring, although there seems to be a consistent theme of the requests. And I just actually pulled up the frequently asked questions guidance that was issued on Monday dealing with what banks are required to do. And the question, it's actually listed as question 1 in the FAQ, talks about what are the banks required? What type of documentation do they need to look for? Do they need to actually review and certify all the information that an applicant is submitting, supporting their average monthly payroll costs? So that was the question. The answer is that the banks don't have to basically recalculate all the information that's being submitted by the applicants. The Q&A actually provides guidance that it's really the responsibility of the borrower. The borrower must attest to the accuracy of those calculations. But lenders are expected to perform a good faith review in a reasonable time frame of the borrower's calculations, supporting documentations concerning that average monthly payroll cost. That goes on to talk about the level of diligence that may be required by a lender will be informed by the quality of the supporting documents that are supplied by the borrower or the applicant. And they suggest that minimal review of the calculations based on a payroll report by a recognized third-party payroll processor, for example, would be reasonable. So the guidance, as I read into the Q&A, is that the more information that you can provide with your application that has supporting substantiation for any amount that you're going to include in your average monthly payroll cost, and the extent that it can be based off a third-party payroll service provider report, I think that will actually expedite the review process that the banks will do and hopefully get these applications over to the SBA and approved on a much more timely basis. So just some of the things that we've been seeing so far. One is you have to be a business that was existing or in operation before February 15th, 2020 with employees who you paid salaries and payroll taxes. With the exception to that is if you're an independent contractor or sole proprietor, you don't have to actually have employees that you paid salaries or payroll taxes. So one of the requests that we've been seeing the banks ask for is a payroll register for the period that covers that February 15, 2020 timeframe. That's one of the pieces of information that banks are asking for. In addition to, there's a standardized SBA form 2483. That's the application for the PPP loan. So banks are asking for the applicants to fill out the form 2483. As Sherry indicated, the banks may have different kind of forms, and I've seen several that actually have kind of a web-based platform where they ask you to enter different information on their web-based portal regarding average monthly payroll, the different components of that. Many of the banks actually have an existing what we call a loan calculator. So the loan calculator will actually go through the various components that Sherry talked on as far as what the gross compensation was for the applicable loan period, any state and local employer taxes that you're adding in there, any employer share of health care costs that you're adding into there, and any retirement benefits. You're also entitled to also add in there any employer share retirement benefits that you provide to your employee. There's actually been a lot of discussion. One of the issues that we had early on was what period do you provide this payroll information? Do you provide it on the 12 months preceding the loan application date, or do you provide it on the 2019 calendar year basis? And that would go true for any of the other supporting expenses that would qualify, for example, health care, retirement benefits, state and local taxes, employer share. So there's actually a lot of back and forth. The final guidance in the Q&A that came out as of April 6th on Monday was that you could use either. It could be a calendar year, it could be on the trailing 12-month basis preceding the loan application date. It really is going to depend upon what the bank specifies, however, in their loan application. So just be aware of that. So typically the banks are also asking for your quarterly filed 941s. That's actually your payroll tax filings on each quarter. They want to see your 940, which is your unemployment tax filing, the federal unemployment tax filing, which shows payroll on a year-to-date basis. Typically, you want to see some type of payroll registers for the entire period that covers that payroll. So if you're using a 2019 payroll period, calendar year payroll period, your year-to-date payroll register, that would show your gross wages for that entire period of time. If you're doing it on a trailing 12-month basis, typically you're going to want to see the monthly payroll registers. And with the loan calculator, you'd want to see the gross payroll for every single one of those months. To the extent you get a what's called a CARES Act, a lot of the third-party payroll service providers like ADP, Paychecks, Paycom, for example, they're actually providing their clients what's called a CARES Act report, which shows the covered payroll for that period of time, either January through December of 2019 or on that trailing 12-month basis. Also typically would include in that the state and local taxes, employer share, and if they have the information available, the healthcare employer portion in that as well. In addition, anything else that you provide support, that you're factoring into your average payroll costs. So for example, employer healthcare cost would be, you'd want to see, support for the amounts that you're claiming there. Any state and local taxes that you're claiming in your average payroll costs, you'd want to see the support. And same thing with the retirement benefits. So typically that could be, a detailed general ledger report out of your general ledger, showing the healthcare, the detailed support for the number. May also include copies of invoices for healthcare and those things as well. So each bank's going to require a little bit different, just be aware of that. So a couple things, just one thing for those that are sole proprietor, self-employed. In addition, since you typically may not have payroll, the banks are asking for things like your 1099 miss that you're receiving from your customers. And they're going to be requiring likely income and expense details from the sole proprietorship so that they could actually see, okay, that self-employment income that you're claiming. As Sherry indicated, a listing of distributions that you may have taken out of the business during the year might be something also that they request. Frankly, I haven't seen any of these from banks, what they're requesting in the case of an independent contractor. And I think possibly that's because the banks are still trying to figure out what they need. And as Sherry indicated, the applications, the initial date was the 10th of April that they would start accepting this. So I think that was really covering the part that I wanted to cover. Now, Kyle's going to cover the piece about loan forgiveness.
Great, thank you, Lee. So everyone's asking, will the loan be forgiven? Well, we certainly hope so. So in order for the loan to be forgiven, the borrower will have to make eligible expenditures over the first 8-week period, which begins on the date of origination of the loan. So what does this mean? So this means that once the bank has approved you and has given you the money to expend on eligible costs, you have 8 weeks to incur and pay for those costs in order for the cost to be considered eligible for the loan to be forgiven. So as we talked about a little bit before, eligible costs consist of payroll costs using the same definition that was included before to determine the loan eligibility. They also include interest on mortgage obligations that are incurred in the ordinary course of business, and those mortgage obligations would have had to have been there as of February 15th, 2020. Eligible costs also consist of rent or other lease payments on any existing agreements, and also the provision for payments on utilities. So this could be electricity, water, telephone. Don't forget about any cell phones that are required as part of your ongoing business operations. So it's important for borrowers over this 8-week time period to project out what their likely costs are going to be, and based on the original loan base or basis, how the proceeds from the loan, the amount, how is the borrower going to spend the proceeds, and will they spend enough for the loan to be ultimately forgiven? There's a caveat that borrowers are going to have to maintain a pre-crisis level of full-time equivalent employees and make sure that there is no reduction in payroll, wage costs that exceed 25%. So that's another factor to consider when you're looking at the eligibility to determine if the loan is going to be forgiven. So in terms of the makeup of the eligible costs, not more than 25% of your costs can be on non-payroll costs. So non-payroll costs consist of the interest on mortgages, any rent or lease obligations, and utility costs, which means that at least 75% of your costs under the loan must be used towards eligible payroll. And as it relates to the forgiveness, as long as the applicant or the borrower is able to maintain their pre-crisis level of full-time equivalent employees and spends the money in accordance with the guidelines in terms of the eligibility, the amount will be forgiven. If there is a reduction in the headcount or the full-time equivalency, or there's a reduction of wages in excess of 25% to the employees, then a portion of the loan would not be forgiven, and the portion related to the unforgiven amount is going to be prorated based on that reduction in the number of employees or the reduction in the wages. So I think the common theme is that things continue to evolve, additional guidance continues to be provided, FAQs or frequently asked questions continue to come out. So as it relates to the loan being forgiven, additional guidance should be forthcoming, which should provide a little more clarity in terms of what the calculation actually looks like, what the measurement period is for the full-time equivalency. Questions such as, is the full-time equivalency over the 8-week period, or is it at the end of the 8-week period? Is it as of June 30th, 2020? So we think more clarification will come out as it relates to the forgiveness. In terms of the tax treatment, so this is really important because remember, this is a loan. So loans typically, if they're forgiven, create what's called cancellation of debt income. So under the provisions of the Act, the amounts that are forgiven are not to be included in gross income of the borrower. So this is good news. So what this means is if you receive loan proceeds and they're forgiven, it does not create taxable income for the borrower. So how is this all going to work? So in terms of the forgiveness application process, that's yet to evolve. So more guidance will come out. There will be prescribed forms that banks will provide, or applications will come out from the SBA. But essentially the Act and interim guidance requires that the lender will have 60 days to grant or deny the forgiveness of the loan. So once they receive the forgiveness application, which will consist of a verification of the FTE count, the pay rates, the wages, the eligible expenditures over that 8-week period on costs such as payroll, interest on mortgage obligations, rent or lease payments, as well as utility payments. The bank will have to review the information to determine if the information is accurate and correct, and the borrower will have to make attestation or certify that the information that they've provided is complete and accurate and true. And they will also have to certify that the payments that were made are actually had occurred for the forgiveness to occur. There may be other documentation that the SBA administrator requires for the forgiveness application, but again, as things continue to evolve, we'll have more concrete information and clarity about the forgiveness application process. So what can Mercadien do to help you? So Mercadien has developed a menu of services related to the PPP loan program. So we're helping clients from start to finish as it relates to either completing their application, reviewing their application. We can provide services around cash flow projection or cash flow management. We can help clients review their cash flow projections and identify any gaps in funding, which likely would require the borrower to seek additional loans potentially. There's other programs that are available. And at the end of the process, we can help with the loan forgiveness application preparation and the grant management process, including the reporting that may be required to the lender for the loan to ultimately be forgiven. And we can review any loan forgiveness applications that are prepared, as well as provide any general advisory services in connection with any issues that borrowers are facing or clients are facing dealing with the COVID-19 crisis. So that's a general overview of the program and the application process and the high-level forgiveness overview. Now I'll turn it back over to Frank to address any questions that have come in or that have been received prior to today.
Sure. Thank you, Sherry,
Sure.
Kyle, for that
Frank.
informative presentation. Yep, Sherry, did you have a question?
Yeah, well, I just wanted to make a broad comment before we get into the Q&A. So one of the things that I am counseling every client to do is it goes back to the cash flow piece. So part of the problem in the chaos is there's so much incoming information that it's hard to compartmentalize it, pull it apart, digest it, and figure out what the best plan of action is. So I really believe that it starts with cash flow. And every business should be starting today, projecting out where they think they're going to be by June 30th at a minimum, and likely till the end of the calendar year. So how is this impacting them from a gross receipts and revenue standpoint? And what expenses can they defer? Meaning, can they slow down or modify their payments to their vendors? Can they request forgiveness of certain, and waiver of certain payments? What can they do with their workforce in terms of downsizing, laying them off for a period of time prior to them making application for these funds that we just talked about? And really just looking at every angle to make sure that their business remains viable through the end of June 30 and then into, the rest of the year. So I don't think you can underestimate the power of being in control of your cash flow and understanding where you think you're going to be and trying to get information and make decisions about how best to move forward.
Absolutely. Thank you, Sherry. To be respectful of everyone's time, we'll jump into the Q&A, and we had a number of questions submitted in advance, as well as a number of them are coming through our live chat feature. So we'll do what we can to address as many as possible, but just be aware that this entire presentation and the recording will be uploaded to our website if you want to reference it in the future. Sherry, if I could direct the first question to you. As it relates to the 25% reduction in wages based on what you and Kyle had outlined earlier, is that 25% reduction in wages based on a per employee basis or the entire employee pool? Well,
that's a really great question. And based on what I have read, it appears as though it's on an employee by employee basis. So to the extent that you have 10 employees and 2 of them aren't restored to full time, if they dip below 25% reduction in their wages, then up to the 100,000, then you may be having to repay, or let's put it this way, you may not be able to have the entire loan amount forgiven. It'll impact your loan forgiveness. But again, we're going to look for more guidance on that. I'm sure more guidance will be coming out as to how to make those calculations.
And Sherry, I think it goes back to the spirit of the act. So just a real simple example. If you have a sole proprietor that has 2 employees, the spirit of the act is to gainfully reestablish the employment level. So bring those in, if they've laid off their employees, bring those employees back and get them back on the payroll, and not to draw down on payroll costs just for the owner, the sole proprietor of the business. So the whole spirit of the act is really to make sure that employees who were employed pre-crisis have now been re-employed, or we're continuing to pay them at the same level we were paying them prior to COVID-19.
Right, but in your cash flow planning, you may decide for sustainability purposes that you have to reduce their pay a bit, and as long as you don't reduce it by more than 25%, then you should be okay with the forgiveness.
So can temporary workers through a staffing company be counted in payroll costs, Kyle?
Can you ask that question again, Frank?
Can temporary workers through a staffing company be counted in a borrower's payroll costs?
So temporary employees from a staffing agency?
Yes.
Sherry, do you know the answer to that one?
I think that it depends on who's the employer. So if you're paying the temp agency for the resource, then I believe that the temp agency is the employer, and that they would be the agency, the temp agency would make their own application.
Yeah, I think that would be accurate, Sherry, based on what I understand too. And I just wanted to highlight, there is a question, a Q&A that was raised about not temporary agencies, but where you actually use a professional employer organization, a PEO, or you're part of the PEO group, and basically there's some guidance that says, that you basically would take credit, those would be your employees for purposes of, the P loan application, but there is some additional guidance specific to PEOs that's addressed in that Q&A document that's up on the SBA website, if anyone has that.
Yeah, it's question 10.
Mm-hmm.
Lee, can you talk a little bit about the affiliation rules and when a waiver might be granted?
Yeah, so the SBA actually, the SBA typically has what's referred to as affiliation rules. So the intent of the SBA is to provide loans to small businesses, and there's actually by industry type on the SBA website, there's a listing of various industry types and what they classify those to be as small businesses or not. For purposes of the PPP, the general rule is 500 employees or less. However, each industry has some different rules, specific rules on that. So we'd encourage all listeners to go to the SBA and actually check the industry that they work on, that they're in, to see what the specific size regulations would be for that. And it could be, employee or payroll. Certain industries have different ones. But as far as the affiliation rules, they gave some guidance on April 3rd, some revised guidance on April 3rd about how the affiliation rules work for PPP loans, which actually is generally the guidance is if you're owned by a shareholder that has 50% greater ownership, that you actually have to look at kind of the businesses that they're involved in for aggregating the number of employee counts. So if you're owned by, say, a private equity group, 75% of your business is owned by a private equity group, or 100% owned by a private equity group, you'd actually have to look up to the private equity group and look at the entities that they have control over and aggregate them for the affiliation rules. So it's a bit complicated. I would urge anyone that has that type of structure where a shareholder that has a greater than 50% ownership interest in your organization or business that you look to these affiliation rules. There's some other ones that deal with not just ownership, but also if there's like management, where there's management or those in charge of management that basically could control the business, that you may have to look to them and the related entities and businesses that they also own and control. So it's a little bit convoluted. So I just make people aware of that.
And for our not-for-profit clients, Frank, there is no such notion of ownership. So it really goes to the control question. So if organizations are affiliated with almost like a parent organization, then it's possible that their brother and sister organizations that are affiliated will need to be counted together, similar to the private equity example.
To that point, as it relates to not-for-profits, when a borrower in the not-for-profit space is filling out a PPP or even an EIDL application, who should be listed as the owner of the nonprofit organization? Or what are your thoughts around that?
That's a really good question because nobody owns it, do they? So what we've been doing is counseling our clients to put either the president or the CEO, it could be the chair of the board. And some of the applications that we were working with over the weekend don't allow you to put 0% ownership. So we were just putting 20% in there just to get the application processed. Again, it's about getting the things processed and then giving the documentation to back up what the facts and circumstances are for which you're applying.
We have a question about 1099 employees working 40 hours a week for a nonprofit. Can the not-for-profit under that circumstance include those costs in its calculation?
No.
1099 independent contractors were removed from the original guidance that came out. So they're in a class of themselves, and they would be eligible to make their own application coming this Friday.
Correct.
So what if you're an organization with more than one lending relationship? We're encouraging folks to talk to their existing bank or financial institution. But if I have a relationship with more than one lender, can I apply for the PPP loan with more than one of my lender relationships? Sherry, you want to take?
Yeah, go ahead. I'm sorry.
I don't know. When you go on the when you actually fill out the application, it asks if you have applied at any other institution for similar funds. So you would have to disclose. I guess what I would encourage my clients to do is to talk to the bank and tell them what your situation is, find out what are the chances of getting a loan based on everything that they know about what their bank's lending capability is. And, it's like, am I at the bottom of the pile? What's the likelihood? Hopefully you've got a relationship with somebody at that bank where you can have that candid conversation and then say, well, listen, if you think, my chances of getting a loan are not that great here, should or can I go apply somewhere else as well?
Yeah, the only thing I would add, Sherry, to that is just, I'm not sure about applying for the loan, but you clearly can't receive two PPP loan proceeds. So that would be an issue if you did that. So you actually have to certify that during that period.
I agree.
Yeah.
I agree.
It is interesting because I have a client right now I'm working with, and their bank has not opened up to accept applications yet. And, you hear all this out there that the funding's going to dry up. Congress is saying that they're hoping to provide additional funding for this, but, first come, first serve is what we're hearing. So, everyone's getting really anxious, like, get your application in as fast as you can. And, if their bank's not being responsive, it's a really good question. I mean, what do you do? Especially if the other banks, larger banks, are saying, well, we're not accepting them only on behalf of our existing customers. So, I think I would agree. I would urge you to talk to both your banks and see which one you think you have a better shot of getting your application in.
Thanks, Lee. I think we have time
You
for
know,
one more question. And Lee, if you
Okay.
don't mind, feel free to jump in and answer this one. Assuming a borrower receives the funds, what advice would you give the client and the borrower in this case with respect to how they should track the money so that it's used on eligible expenses so that it really does morph from a loan to what is likely to be a grant in the most efficient way possible so that it's not a disruption to their business, but it essentially keeps them in the position they want to end up in?
Yeah, so Frank, I think you directed that question to me. I might punt that to Sherry, if you don't mind.
So I can take that.
I know you guys have been talking a lot about that from more the grant management standpoint.
Yeah, I mean, so
Yeah,
what I've been advising my clients on and what I've been doing is essentially preparing a projection or a cash flow forecast on how those proceeds are going to be used for costs such as payroll, utilities, and any rent payments. So as long as you're able to quantify your costs and make sure that you're able to capture the full eligibility of the proceeds from the loan for the loan to be forgiven. That's what I've been advising my clients on and what I've been doing in terms of preparing kind of a cash flow projection on how we're going to use the proceeds from the loan. Sherry, I don't know if you wanted to add anything to that.
Well, I would just, every week or however frequently you're paying payroll and paying your expenses, but I would say not less than at the end of the month, really just make a, record use your QuickBooks or whatever you're doing for bookkeeping purposes, record your expenses in those 4 cost categories and make sure that you're on target to meet whatever the forgiveness criteria are for your situation. But don't forget, you have the headcount issues too. So it's not just the expenditures, it's your headcount and it's your salary reduction. That's why we added this whole, we're likening it to managing a grant, which a lot of our not-for-profit clients know how to manage grants. So this really becomes a grant management process with the outcomes being FTEs and restoring payroll to the pre-crisis level.
Right. So with that, I think we're out of time. On behalf of myself and my colleagues, we want to thank you for joining us. We hope you found the information to be helpful. It will be posted on our website for future reference, so feel free to check www.mercadien.com. If Mercadien or any of us on the call today could be of further assistance to you, whether it be to evaluate the PPP or other relief options available, or if it's just to help you through any other business challenges you're facing. We're in this together. Our contact information is up on your screen, or again, you can visit us on our website. But thank you again. This too shall pass, and I think together we'll overcome the challenges ahead. So enjoy the rest of your day and be well. Thank you very much.